All right, great. Let's come back to order for a topic that actually has been a topic we've been discussing all through the morning sessions as well, that really is a component of everything we're planning to talk about at this conference, but this panel puts it front and center, and that is the powers of the executive. And to discuss that issue as panelists, we have a panel that is distinguished not only by its really remarkable academic achievements, but also by the achievements of the members of this panel in government. Jeff Powell, David Barron, and Vicki Jackson are all veterans of the Office of Legal Counsel. Bill Marshall of the White House Counsel's Office, where he used to make sure that OLC was responsive to the power of the executive. And Mike Gerhardt, who hasn't held formal office within that structure, but is frequently called upon for his insights by individuals both within the executive branch and within Congress. So without further ado, I want to turn it over to them.
The OLC opinion has a very straightforward approach to the president's power to engage in whatever interrogation techniques that he feels appropriate. One of the lines from the OLC opinion says simply, as the Supreme Court has recognized, and we will explain further below, the president enjoys complete discretion in the exercise of his commander-in-chief authority and in conducting operations against hostile forces. Now, we will get to whether or not an interrogation is an operation against a hostile force, which is an issue that Scott Silliman alluded to earlier today. But before we get to that, I think where I'd like to begin the conversation is just an examination of the parameters of the presidential power as commander-in-chief generally. And as just some introductory remarks, how do we figure out what that is? Well, one answer is text. The Justice Department and OLC rely specifically on the commander-in-chief power and the vesting power in Article 2. But Congress also has significant powers with respect to engaging in actions against hostile combatants. That would include the power to declare war, obviously, the power to raise and maintain an army, and various other such powers like that. The division is not necessarily clear in the text. Or we could take a look at the constitutional structure. The Article 2's, the citation to Article 2, the power of the president, as the executive, it can be taken as a structural argument, not just simply a textual one, the division between executive power and legislative power. We can look towards history, and there have been a lot of examples of similar kinds of fights between Congress and the president. President Lincoln fought off an often combative Congress who tried to direct who was going to be chosen as a general, what kind of battle tactics the Union Army should follow. President Nixon faced controversy over whether or not he could bomb Cambodia. The Congress said no. The Boland Amendment controversy during the Reagan administration on appropriations to support the Iran-Contras. The Clinton Justice Department wrote a memorandum suggesting that if Congress tried to prohibit the president from putting U.S. forces under UN control, that would be illegal. And other kinds of historical exercise of the power of the president in times of combat, which include very extensive powers dealing with the president's ability to control the territories of California and New Mexico after the wars involved or are taking over those particular territories. So we have history. Henry Monahan wrote about the protective power of the president, the ability of the president and the right and the obligation of the president to protect American citizens and security. And I think even beyond all of that, we can just throw the exigencies of modern time when war happens so quickly, when actions, including obviously 9/11, take place literally out of the blue. Who else has the ability to be able to respond in a way that we would like? Now, how do we try to figure out where the limits of one sort of power begin and the limits of one sort of power end? And to begin that discussion, let me first turn it over to Jeff Powell for a few thoughts on broader parameters in this discussion and then try to deal with some specifics and see where we go from there.
Thanks, Bill. Let me just first make an observation, and I'm sorry I don't see Chris Schrader here, he's not back yet, about what I think was a real stroke of genius on Chris's part in the way he structured this event. From a certain aspect of legal logic, one might think that, well, one could say quite correctly that this whole event is about the scope of executive power. And therefore, from a certain sort of doctrinal mindset, one might have said, well, this panel ought to be first, because after all, we're talking about the basic underlying constitutional issues, which in a domestic setting, at any rate, have to be controlling. But this is not the first panel. Instead, this panel is sandwiched in between panels in which the moral and political questions raised by war, raised by interrogation, raised by detention, have all been sort of actively and clearly and not abstractly in the discussion. And I think that's very important because it's one of the most fatal mistake to make would be to forget that these are moral and political issues, and to my judgment at least, only secondarily, in a sense, legal issues. That said, I think one of the things that it will be a very good thing if it happens, is for the controversy over the various DOJ and White House counsel's office memos. If the controversy over those memos leads us to get the conversation about things like the commander-in-chief power back on track, because I think that conversation is off track, and indeed has been off track for a long time, because there are some persistent errors that people tend to make in the conversation. And let me give you three that seem to me to be both extremely important errors and to be brought up in a live fashion by the various memoranda from the administration that we're discussing today. The first error tends to be committed by political liberals, although there's no necessity that you be a liberal to make the mistake. It's the error of thinking, or rather of assuming, that the entire panoply of presidential action and authority in the modern era is, at the starting point and as a per se matter, illegitimate. That what the modern presidency is in the areas of foreign affairs and national security is an imperial presidency, and that that's simply an assumption. And if you don't think that's an assumption that even brilliant constitutional lawyers can work with without even examining, go read the beginning of the great late John Hart Ely's book on war and responsibility, where it takes him a sum total of about 1.5 pages to simply assume that and then march on. I think that's a mistake. It's at least a debatable starting point for any legal analysis that says that the entire reality of what you're trying to discuss is just completely wrong and you've got the solution. The second mistake is typically made by conservatives, political conservatives, although there's no necessity that you be a conservative to make it. And that's, Bill quoted nicely the language of the OLC memo talking about the Commander-in-Chief clause giving the President complete discretion. Complete discretion. The basic mistake that I'm talking about is one where, having found or concluded that the President has independent, substantial authority, that therefore not only may the President act in the absence of Congress, not only may the President perhaps act sometimes in the teeth of Congress, but that furthermore, Congress can't act as if presidential authority somehow could oust congressional jurisdiction from an area. That makes no sense whatsoever in terms of a text which says, among other things, and you will recall, Congress has the power to make all laws necessary and proper for carrying into execution all powers vested by this Constitution in the government of the United States or in any department or officer thereof. That's the second mistake. The third mistake, I think, is one that particularly the Torture Act memo really puts front and center before us, and that is that the rubber hits the road in these issues much of the time, I think the vast majority of the time, not in overt, clear conflicts where the executive branch says, we have the authority to do this in the teeth of congressional commands to the contrary, but rather whether the executive branch says, as in the Torture Act memo, well, If we construed Congress's language to do what it might otherwise have been thought to do, this would create a grave and serious constitutional problem. Therefore, in order to avoid constitutional difficulties, we will construe Congress's language to say that X means not X, or something close to it. And I think one of the central issues for this generation of constitutional lawyers and others interested in these matters is to address the problem of executive branch interpretation that is, in fact, makes a Mickey Mouse out of Congress.
There are different kinds of restrictions that Congress can impose on the president in his ability to conduct operations against hostile forces. He could put limits on where the attack. Congress could try to limit where the attacks could take place. Try to interfere with the command structure, as Congress did during the Civil War. Try to tell the president has to take a particular stand, whether to be neutral or not in a particular conflict. To try to dictate tactics that might or might not include torture, depending on whether we define torture and interrogation as a tactic of war. Geopolitical inclusion or exclusion, they could choose to say that Cambodia is off limits or not off limits. But in addition to the types of restrictions, you might think about when Congress imposes those restrictions. Does it make a difference if Congress imposes a restriction before there's been any presidential action? Say, for example, you can't use tactical nuclear weapons. Or decides to make that decision when it looks like the president may or may not use tactical weapons in a given particular circumstances. There might be different questions as to where the restrictions apply. What is the battlefield? Where is the battlefield where the president is conducting these kinds of operations? There might be a question as to the basis of the restrictions. Are they general kinds of prohibitions? You can't use landmines here at a particular battlefield. Or whether they're a more general kind of prohibition. You can't use landmines at all. Or whether Congress is doing what it's doing pursuant to its appropriations power or as a general kind of limitation. So those are the kinds of different types of approaches Congress could take. Let's start off with a real simple one. Let's assume, before we get to interrogation tactics, let's just assume, David, and start with you. Let's assume Congress passes a law which says generally that the president cannot use landmines in any conflict. Past 5 years before a particular president comes in and wants to use landmines. Is that constitutional?
I mean, frame that way with that question. I mean, one answer is yes. Yes, it is constitutional, but I don't know that it's going to be most helpful for us to work through the particularities of whether that is or isn't. What I want to emphasize in answering yes is how you could come to the answer yes to that question, and how doing so results from a completely different process of imagining executive power than comes from the OLC memo. The criteria that Bill lays down isn't just a set of criteria, it's already an imagined idea of how one would think through the problem, which is extremely different from the way that, at least one conventional way of thinking through the problem, which is the president is commander-in-chief. As commander-in-chief, he has to be able to prosecute the war. All things incident to effective prosecution of the war, therefore, are constitutional. Any effort to infringe upon his ability to effectively manage the war are therefore unconstitutional. Now, the way Bill's put it is that that's just a complete misreading of the document, not because of the outcome in the particular case, but because the question you're asking is off. The way Bill puts it is to first imagine that the commander-in-chief power is not usefully understood as simply the power to effectively wage war, that there are component and constituent parts of it, some of which might stand in a different position with respect to congressional action than others. The power to command your troops, to choose the actual commanders, might be very different than your power to choose which weapons to use and when. Each are part of the commander-in-chief power at some level, but it's important to disaggregate what's in that box. And there's no indication from the OLC memo, it's just an example of, I think, how you can go wrong, that would be necessary. In fact, just the opposite. Because battlefield tactics are within the command power of the president, therefore, interrogation must be as well, as if anything effective to the prosecution of the war follows. The second thing that I think you can go awry on, and what leads me to suggest that the answer would be yes with respect to landmines, has to do with the difference between permission and prohibition. In the event that that a war was authorized, or even in the event it was not authorized, and simply the president asserting, as the Clinton administration thought he could in the Haiti situation, commits troops, what is available to him upon committing troops? Are landmines available to him? One might plausibly think yes. As commander-in-chief, he's got to be able to effectively use resources. They are available. He can mine the harbor, pursuant to his power, even though Congress didn't authorize even going to Haiti, let alone using landmines in the harbor. But that wouldn't tell you anything about whether were Congress now to say, have a statute in place prohibiting the use of landmines, though not prohibiting him going to Haiti in the first place, that upon going to Haiti, he should therefore also be able to trump the prohibition against the landmines. So I think the key thing is the approach that one uses. Now, having said that, I just want to, and I think a lot of this tracks what I imagine a lot of us on the panel believe, so to try to pick a quarrel. Jeff suggests, of course, it's completely wrong to think that Congress's jurisdiction over the president would ever be completely ousted. And yet, while Jeff was at OLC, the Office of Legal Counsel wrote an opinion which sure sounds a lot like in the end they believe you can completely oust Congress from certain questions over the power of the commander-in-chief. Namely, Congress wanted to say the president could not put U.S. troops under UN command, and OLC wrote an opinion saying that is unconstitutional. The president can choose to put all U.S. troops under UN commander if he so chooses. And there's nothing in the opinion that suggests, of course, if you actually pass the statute, then we'd listen to you. Right? There's every indication from that opinion that if you pass that statute and the president in a conflict wanted to shift all power to the UN, he would do so in the teeth of that statute. So how one puts together a sense that we can completely oust Congress from jurisdiction and a sense that it's important to share power and understand that it's shared, I think, is all the difficulty in the situation.
Vicki?
As David was talking, I was reviewing one of my little pocket constitutions, of which I had several, and I know earlier speakers mentioned provisions dealing with congressional power, one of which is to make rules for the government and regulation of the land and naval forces. And one of the things that I want to suggest that we might actually have consensus on, but at a fairly high level of generality, is that it is a mistake to analyze the commander-in-chief powers in isolation from the many Article I powers of Congress that deal also with armed forces and foreign relations. So we have not only the power to make rules, but to provide and maintain a navy and to raise and support armies and to define offenses against the law of nations and to make rules concerning captures on land and water, all of which sound like they have something to do with matters that also fall into the commander-in-chief power. So as a methodological matter, I want to suggest, in contrast to seeking disagreement, I want to look for some agreement here, which we may not find, that as a methodological matter, one needs to look at congressional power before making the kind of strong statements with respect to the commander-in-chief power in the face of congressional prohibitions. That's my immediate comment. I could go on to something else, but I don't want to usurp.
Mike?
Okay, how much time do I have? Well, several things occur to me. Let me pick up, I think, where Vicki's left off and talk about methodology, because I do think that a critical issue for all of us to think about is the approach that is taken in reaching certain constitutional conclusions. Now, the critical thing is, first, who's making the constitutional judgments? President obviously has numerous lawyers advising him. Members of Congress have the same. We haven't mentioned courts yet, but I'm about to do that in a minute in a little more detail. But I'm going to suggest that oftentimes the choice of methodology may turn a great deal on the institutional interests that are at stake and the institutions that are making those judgments.
We don't pay a lot of attention to these kinds of considerations, I think, when we talk about courts. But here, I think we've got to. Will OLC memos be written differently if they are written by people who happen to be part of a Republican administration or part of a Democratic administration? Also, what kinds of signals are they getting from the White House? And to what extent do they interact with members of Congress? And where do they look, of course, to reach their judgments? There are some real serious methodological issues here, and I think we ought to sort of think them through as to how things get made in the first place. But then secondly, what's the criteria we would use? What are the criteria we would use for evaluating them? And I'm going to suggest as well that I think that Congress and the President usually are very much at odds because they have different institutional interests when it comes to war powers, and therefore they employ different criteria for evaluating the actions of the other branches. Of course, Congress is going to emphasize the powers that it's got. Of course, the President will look almost always, first and foremost, at his powers. But there's a second thing, that is structure. We've mentioned structure. Structure raises various inferences which may cut in one way or another. A third is, how does precedent matter? And I happen to be doing a book on precedent, so I'm obsessed with this. But my current chapter is on non-judicial precedent. To what extent does precedent, historical practice outside the courts, matter to each of these branches? My guess is the President will emphasize more of those precedents that, with which he's familiar, his lawyers are familiar. Congressional precedents may also then be emphasized by members of Congress. Yet another thing to consider is just prudence or consequences. What are the ramifications of particular actions? And here the critical question concerns the extent to which the different branches and their leaders and their counsel are sensitive to the ramifications for their particular branches. In other words, the President's lawyers are responsible for his branch. They're not responsible for what happens in Congress. So they're going to be much more sensitive to the outcomes that will impede what would be the outcomes for their branch. And they'll leave it to members of Congress and their counsel to deal with those, to deal with theirs. And then lastly, we haven't talked about sort of original understanding. To what extent is the framers' intent, I only leave it last, not least, of course, but to what extent does the framers' intent factor in here? I'll suggest, of course, it's not very definitive or very helpful when we deal with things like torture and sort of the current war against terrorism. But I will end simply by saying that I think we have a dilemma in that the institutions have their own self-interest to protect, and so who is, in a sense, or how can we ensure that whatever conflicts between them are resolved in a way that sort of benefits ultimately the American people?
Well, what I hear from everybody is saying, okay, we've got a lot of different ways we can analyze this particular problem. There are a lot of tools in our toolbox that we can play with in doing this. We shouldn't come up with simplistic answers one way or another. But other than David saying, okay, Congress can ban landmines, we haven't got much in the way of specifics of how we decide specific issues. So how do we decide that it's improper for Congress to tell the President who he's going to have leading forces? That's not good. But Congress can tell the President that he can't use landmines.
I mean, this is my instinct on this, and that's all they really are, instincts, is that using the methodology that we discussed, given the realm of power that Congress has as a textual matter and structurally, that the scope of the President's commander-in-chief power as a trumping power over statute is exceedingly narrow, actually much narrower than statements that you can find in straight dicta suggest, because almost all of those statements invariably are made by either attorney generals or Supreme Court justices in instances in which there is no conflicting statute. And in fact, almost the only precedent, legal precedent out there where there is an instance of the President asserting power to trump a statute is directly contrary to the President's power. And in fact, it even occurs in a case in which there's a wartime situation involving battlefield tactics, which is Little versus Bareem, if I'm reading it right. So that the sort of general notion out that there's some free-floating battlefield tactic power on the President, I start with an incredible degree of skepticism towards. What residuum there seems to me to exist for the commander-in-chief power, I have a tendency to think is almost equivalent to like an appointing power. And what the core of it would be is the power to select commanders. The actual choice of who you command, who's under you and who's above you, would be more likely to be within the realm of the things Congress can't touch than would be any of the substantive operational details. But having stated that, obviously one can think of hypotheticals that press on that point. But as a starting point, I guess that's where I'm at.
Mike, you look like you want to jump in?
I don't really disagree with David at all. I would only add that I think that one of the things to consider is, of course, the ramifications of the absence of judicial review. We've got to, particularly when you're involved in military conflicts, that is rare to say the least, and ultimately not very meaningful to the extent it exists at all. So what becomes particularly important here is that we are talking about a process in which the actors, including the council, understand that the critical checks are political. And that whatever choices they make about sources or methodology or about institutional interests, I think they understand to some extent that those choices are choices and ultimately are not so much, I think, going to end up being second-guessed by courts, at least within our, under the current paradigm. But instead, they have to sort of withstand political reprisals or political heat.
Well, the political heat on the presidential action is from the Congress. Now, if that's true, then why doesn't David have the presumption exactly backwards? Instead of saying that the president, the Congress, in effect saying that the president doesn't trump Congress, is in effect saying Congress trumps the president in most circumstances. Why should we go to that way? Because we don't need to do that if Congress has got the power of enforcement, because there are all kinds of weapons that Congress can use against the president. So we can give the president a little bit of a leash here, and then let Congress rein him in if necessary. Vicki?
But ultimately, you still get back to a constitutional question on what the appropriate tools are for Congress. So I'm not entirely sure that the fact that that many of the safeguards are in the political process it avoids the question. I was thinking about the War Powers Resolution. What if it was enacted without the 60-day provision and was intended to prevent even defensive uses of forces? I think at that point you might say this is an unconstitutional constraint on the president's commander-in-chief power. At the same time, an idea that I know I've talked about with David and others, if we go with the landmine example, there might be a difference, and Bill, you raised this, between a statute that generally says we've decided in the United States we're not going to use landmines, period. They're prohibited. And on the other hand, there's an ongoing conflict, and landmines are not generally prohibited, and Congress says, but you can't use them in this harbor. Now, at that point, it starts to feel somewhat more like choosing tactics about waging an ongoing war. Everybody's smart in the audience, and you're going to say, well, there's a slippery slope, and how can you really tell what the difference is, and why should that matter as a matter of principle? And you might say something about Congress's willingness to make a commitment in general, and the kind of lawmaking process that such a general prohibition would ordinarily entail. And on the other hand, making a decision for this time and this moment only, as one that maybe you want to entrust, or you want to say the Constitution is entrusted to the president. So let me put that distinction out for us to talk about.
Yeah, I think Vicki's exactly right that, and I think this is a general feature of the entire area, that many of these judgments are not going to be ones that easily can be resolved by bright line approaches, and there's going to have to be something else going on. On the other hand, I disagree about the landmine in the harbor example as one that I would myself pay much attention to in doing this kind of work, because that strikes me as the kind of extreme hypothetical that gets us off trying to construct a constitutional law to prevent Congress or the president from doing something that no rational Congress or president is going to do. And that's, I think, not the best way to think this through. I myself would, and I'm probably disagreeing a little bit with David here, although I'm not quite sure. I would start with a robust assumption about the scope of the Commander-in-Chief clause. In other words...
As a trumping power?
No.
Okay.
I would start with a robust picture of that, pretty much anything that is necessary and proper, to borrow that language, for the president to successfully use the military forces where it's lawful to do so is within the affirmative scope of that grant of power to the president. But that's just the starting point. Then you ask yourself, if you're looking at like a general landmine statute, you say to yourself, well, does Congress have some conceivable source of power to speak to that? And it seems to me that there are several. One is the one you've already brought up, the Government of the Land and Naval Forces Clause. Another is the fact that the military doesn't exist unless Congress creates it and funds it. Weapon systems can't exist unless the Congress creates them and funds them. It seems to me that we've got a good, solid basis in that for saying that Congress can make judgments, for example, about there will be no landmines purchased with the funds of the United States of America. And I would go further and say that, and furthermore, you may not like pick them up from somebody else.
Can I just, here's a paradox, I think, that emerges from this approach and the approach Vicki's pushing, which is when Congress acts generally in advance, we have a certain degree of comfort they're not interfering with the president's commander-in-chief power, right? We also might have a fair degree of confidence they haven't contemplated the exigency of the circumstance that the president's now facing. So the paradox is that the president now has that exigency, and the reason he wants to disregard the statute is in part because he thinks whoever passed that statute wasn't thinking at all about what I'm now facing. I mean, to some extent, I think that's the argument with respect to the Non-Detention Act. That's the argument with respect to the Torture Act. These people, when they passed this statute, had no idea that al-Qaeda was here, that we really had a ticking time bomb situation potentially, that there could be somebody with a dirty bomb that could blow up New York City. Why should the Torture Act, passed in a very different world with a different set of circumstances, now constrain me? So in that setting, the requirement of generality as a precondition has the virtue of seeming not to usurp the president's tactical power. It has the demerit of not being responsive to the president's quite plausible assertion that for the very reason that it's general and in advance, it's utterly incapable of speaking to the kind of situation that I now am possessed of the insight and particular authority to respond to. So why should I be bound by that? Whereas had they tried to usurp my power at this very moment, now seeing the situation specifically saying, don't torture al-Qaeda, a completely implausible political act to be passed. But were they now to intervene, though maybe slightly less implausible if you think that after Abu Ghraib there's a shift in persons' perceptions about what actually wins the war on terror. Given the face of that statute, Vicki's approach suggests it's now more unconstitutional because they're directly responding to the exigency. On the other hand, you might say it's entitled to much more weight because they're directly responding to the exigency. And how one thinks through that conundrum is unclear to me.
Well, just if I might, there might be a difference for constitutional purposes between the general point is a terrific one about exigencies, and a distinction between that and what it means to command troops. So that if you're in something, and maybe we don't have old-fashioned battlefield situations anymore, maybe that's one of our problems, but to the extent that we do, it seems to me there may be some core area where there is a presidential trump power with respect to congressional efforts to direct how a particular battle in a particular city is fought. Now, so that your general point about this paradox about exigency might be true, and one still might want to have some lines that apply in the situation where you have people in active combat. If I might, I would just say that in sorting out what these areas are in which there might be some area in which either the statute controls or the president, the degree to which things have to be done in secret and really quickly certainly favor, I think, recognizing a stronger degree of power in the president to take decisions because Congress doesn't act fast.
Mike?
Let me go back to the statute that you proposed, because we've left that. We're talking about things, of course, that are not in the statute. We found arguably an exigency exception because we understand or assume that the president has the power to handle emergencies. And the critical, I think, at least question that sort of arises in my mind is, what's our methodology now for construing statutes? Because that statute Bill mentioned didn't have any exceptions a plain reading of that statute would suggest there are no exceptions. But we understand it as well, of course, the conflict, the paradox, that under the circumstances, perhaps presidents sometimes may have to, as Lincoln perhaps said, break one law in order to ensure that all other laws get enforced. But this is, at least I'm going to say respectfully, as somebody who's been, unlike everybody else here, I've been unburdened by political accountability. And so I'm going to suggest that we're looking at this largely still from a presidential point of view. But if we shifted perspective and looked at it from a congressional point of view, what if Congress had thought about this really hard? What if they had deliberated about this? What if it's in all sorts of treaties and other things? Then is there still an exception? Maybe. But to what extent is that due deference?
David, one of the questions I have with your approach is that I thought you gave a great argument in favor of giving the trump card to the president, not to the Congress.
That's what I'm saying. I think that's a
So why are
paradox
you-
with that, because that's why I said a paradox with Vicki's approach, which makes a lot turn on the generality or particularity, or whether it's an ex-ante rule versus a response to the president's action. None of those in the end strike me as all that useful for sorting it out. And I think what I'm more inclined to come back to is what I said at the beginning, is that a key thing is to disaggregate the commander-in-chief power itself, to think about what aspects of power are contained within it when it's asserted. And thinking through the various aspects of the power that are contained within it, I think it becomes possible to see arguments for some of them acting as trumps in a way that others might not. And I suggested that I think the commander aspect, I think there's even a textual reading of the Constitution that you can get somewhere with. When you think about inferior officers, there's a general idea of unity of authority and hierarchy. There's inferior tribunals. This notion of chiefs and non-chiefs runs throughout the text of the Constitution in a way that I think is fairly powerful. I think the broader arguments as you get outside that sphere into general battlefield operations or general battlefield tactics has often been confused with that power of command in a way that I think's dangerous.
But that power from command it comes from a sort of recognition of what the specific issue facing the military forces are at a specific moment. So the president, there's this law that we have against the use of landmines. And the president gets some information indicating, boy, if we could only use it here, it would be so critical for us to use it here, it will save so many troops. He's at the point where he knows more than the Congress ever knew or is likely to know. Why don't we throw, just on the basis of expertise alone, why don't we give the power to the president and say that the president carries the trump, not the Congress?
I mean, you're positing a situation in which the president is likely to be right? And we could also posit situations in which the president is likely to be wrong in these various decisions. And when there's a statute out there that has a seeming prohibition in it, we can't textually find a way to get around it, that the president might be right seems to me, in general, an insufficient basis for arguing that the president has authority to trump a statute, right? I mean, in the domestic sphere, it doesn't even come close to being a good argument. And I don't think when we move to the foreign affairs sphere, it becomes an appreciably better argument, in part because one of the things that I think can easily be done, and maybe Mike was getting at this point, is it's quite easy to get a very stereotyped view of Congress as a bunch of ignorant actors never thinking about the common defense. And I don't think that that's a particularly fair presumption to be operating on when we see the statutes they've passed. When they adopt statutes in the realm of foreign affairs, it's certainly plausible to think that they're considering, on behalf of the nation, the common defense. And, to listen to the panel on torture just earlier, and to read the memo, one indisputable thing is, in passing the Torture Act to implement the Torture Convention, there was a lot of thought on the part of Congress as to what kind of exigencies might arise and how to protect future troops and discretion of the president to engage in various kinds of things. Why? Because they were thinking about more than just protecting people or making a political point. They were trying to think about operationally what would work, and I think they're as much entitled to that presumption as the president is.
The only thing I'm actually in much more sympathy with what David is saying than might have appeared, is that arguments that the president can ignore the law are dangerous. Constitutional democracies rest on laws. And so while we may differ on whether there's some small core of area in which a president, in which a statute would intrude on an area that we want to say is a commander-in-chief power, that even when you minus what is taken away by statute, there's still something there. To have a general approach that says the president can act contrary to a statute when he gets good information that suggests it would be a good idea makes us not a government of laws, but of people. And can I add one point here, which is, as I was thinking about this panel, I was thinking about history and practice, but in a little bit different way than has been mentioned before, which has been history and practice in the executive branch and in Congress. But I was thinking about it in two other senses. One is in the sense of the paradigm, that is to say, people's current lawyers and judges' paradigms, what is in their mind as the situation they're most concerned with. So there's a body of scholarly literature that says you can look at decisions in the Hughes Court and the Warren Court and say what those courts were trying to do was to distinguish the United States from totalitarian regimes. So no coerced confessions, lawyers, and so forth. And I've been trying to figure out what is the paradigm today. And sometimes I think it's a paradigm that's not only about the World Trade Center, but about Mogadishu and Vietnam and the U.S., and something about victims and fear. So that seems to me important to figure out in terms of what is motivating. And the other kind of history that is relevant is what Frankfurter talked about in his opinion in the Youngstown case, which is looking at the experience of other countries, which brings me back to where I started this comment, which is something about the fragility of democratic freedoms, that we have had this amazing run, but it can be very fragile. So that's a reason not to have an approach that says Congress makes general laws, but when the president knows better, he can accept out of it.
Jeff?
Okay, yeah, in response to the exigency point, I think one of the things not to be lost track of is Mike's point about the institutional perspective of people making decisions. I'm pretty certain that if the president actually thinks that, in fact, the United States' security depends on disregarding the landmine statute, guess what? He's going to ignore the statute. I don't think we need to particularly, say, in fact, I don't even think we need to say to him, well, there's some kind of read-in exception. I think there will be an exception in practice. And I think that's something to be kept in mind. And of course, that dovetails exactly with your point that, the institutional perspective of the executive branch is going to lean towards finding that what we think is good policy is not just good policy, but great policy, and not just great policy, but necessary policy. So that's a reality in there. This conversation is making me think about something that was very striking about the conversation in the last panel. One thing that I think has probably surprised some people and was brought up vividly by things Scott Silliman said in the previous panel was the way in which the culture of the uniformed lawyers who were making or wishing to give advice, although not permitted to much of the time, was a very different culture. They started with assumptions that were different than the assumptions of the civilian political appointees who were ignoring or overriding them. And so I think this is to go back to the point I made about statutory construction being a crucial thing. I think some of this one of the issues here is about how you have institutional cultures that build in a kind of responsibility for thinking at least of both sides of legal questions rather than just going in one direction. And then the one other point I wanted to make, and this is about the sort of contrast between ex ante and statutes that are in response. One of the problems with the perspective of people who hold, as I do, strong views of presidential authority, and yet who say, as I also do, that most of the time, for most purposes, the president's authority is subject to override by Congress. One of the problem is that it's very hard for Congress to override the president. And all it takes, is, 1/3 and plus one of one house? A president is in such weak political position when she can't get that, that she's not likely to be doing things that Congress would disapprove of anyway.
Jeff, just your last point, how that relates to the first point potentially, which was that if the president really needs to mind the harbor, he's going to mind the harbor. statute's not going to stand in the way. I guess I just am skeptical of that account. There's a first cut at which it sounds totally reasonable. It's a real exigency. These guys do whatever they need to do. But I don't recall that general disposition being actually the practice. I mean, to the extent that working in the Office of Legal Counsel, people seem to be asking questions quite a lot about what they could or couldn't do as a legal matter, and we had the fiction that upon giving them the opinion, they would listen to it. So, I mean, if you imagine a situation in which they're going to mine the harbor, they want to know whether they mine the harbor, there's a statute saying you absolutely may not mine the harbor. What's the account of what's happening in the White House that leads the harbor to being mined? Now, there's one possibility is through creative construction, we can strew it away. Okay, but I think to make it interesting, we should follow Michael's prescription. That statute is not subject to being construed away. Do you advise the president at that point, absolutely, you may not do it, it's illegal, with the full expectation and hope that he does it? Or do you advise him that you have a constitutional power to trump it because there's an exigency? And I think something of significant turns on which of those two attitudes one has to what the role is. So how do we think through that, in other words?
David, can you clarify that?
Yeah.
Because if I'm not understanding the contrast. Are you saying that latter possible advice, which is there's an exigency exception, is simply a dishonest statement about your view of the statute?
Not at all, but if one has that view, yeah, dishonest as a statutory interpretation matter, yes. Yeah, so that there is no way to construe the statute as having an exigency. Your only options at that point are either the statute controls the president or the president has the power to disregard the statute. Now, I think the nub of the issue to some extent is what is our attitude towards the legitimacy, reasonableness, breadth of circumstances in which it should be an admissible answer for executive branch lawyers to the president that you have the constitutional authority to trump that statute. And I think one can elide the question by saying, not implying that you're trying to elide it, but it can be elided by saying, well, in fact, the exigency will be taken care of. But I actually think, I guess I'm skeptical that that actually will be a practice that will be sufficient over time. And secondly, I don't think it does enough to address the underlying issue of what is the advice to the president as to the legality of his action in that setting.
Mike?
I mean, the first thing is, we know that as a practical matter, statutes are rarely so clear. And so they usually are, as we know, the products of compromise and also perhaps not that specific. I mean, there may be, so that may be one of the reasons why we can imagine getting out from under it. There may be other things that have been passed subsequently, like resolutions that provide some basis for executive disagreement, let's say, or at least noncompliance with that earlier statute. The second thing is that we know that presidents, of course, and particularly in a time of war, are not going to be acting in a vacuum. And so a lot, I think, will depend on the relationship with Congress. He might well not comply with that statute, but my guess is at some level there'll be some consultation with Congress. That might make some difference. I mean, I think a third thing, of course, the dreaded fact of political parties. Are we talking about a circumstance, this is just hypothetical, where one party controls the Congress, one party controls the White House? Or
That's certainly hypothetical.
yeah, it's actually been a nightmare of mine. Or is this a circumstance in which we have divided government? The reason, of course, those things matter is because they provide incentives for pursuing certain arguments or pursuing certain conflicts. And the last thing is timing. Of course, not just, I mean, just comes up last when I mention it, but of course that's crucial. How much time is there to act? How much time is there to consult? And to what extent does the timing impact on the analysis?
I want to invite people from the audience to start intervening in here too. Walter?
I want to put civil disobedience on the table, which was suggested, I think, by either David or Jeff. That is an option. Whether it's a moral option, I want us to discuss. But assume we have a law of general applicability, and Congress has thought about the situation and said we do not want any exceptions to this. The options are comply with the law, tell the president he has the constitutional authority to disregard the law because Congress couldn't have foreseen the exact circumstances, but I want to rule that out. It seems to me that in the hardest cases, the ones where you say that, where one of the traditional moves is to say the president must have the constitutional authority to override the statute, because let me give you a situation in which any president would do it and we would want the president to do it. Why isn't the answer in that situation to say, I'll be White House counsel. Mr. President, I have the opinion from OLC. There's a federal criminal statute that prohibits the use of this technique of war and death. And OLC has concluded, and I concur, that you do not have the constitutional authority to override that. And that is the opinion. In my view, it is unlawful for you to take this act. May I speak to you as a friend? This is a circumstance in which some people would, let me say this to you, 1,000 people have died in this engagement, young people. 10,000 have been severely injured. You face potential criminal liability under a statute that makes it a 5-year felony. I think you should consider whether you should take that step. And the reason I suggest this paradigm is that once you say the president has the authority to override the criminal law, that's the road to Abu Ghraib, right? And the defense of that is, well, what about the extreme circumstances of the person who knows where, he knows where the nuclear device is in Midtown Manhattan? Tell the president, and if you want to be really moral, you'll turn yourself in afterwards. I just posed that as that was sort of what would Gandhi do. Other people make sacrifices, and perhaps sometime the president should take on that responsibility.
And there's a broader constitutional point there too, which is if you always say that the president can trump because of this exigency power, then why have the memorandum in the first place? I mean, it's an exception that can. So it's both the civil disobedience part, and it's also the question that you have to ask that if there is this inherent trumping power, then why bother to say no?
I'm not talking about a trumping power.
I know you are. I know. No, you're saying the opposite. I said if you don't accept your argument.
That is one possible move.
This is like,
No, go ahead.
I mean, this is very much like the argument that Orrin Gross has made about torture. He hasn't made it about the president as such as I remember it, but his argument is that even if on some moral grounds, some people might conclude that there are circumstances, 10,000 dead as opposed to torturing one person, where some people would say, well, it's a terrible thing, but it's a choice of evils, Ignatieff, and you should torture. That it is important, he has argued, that the law be absolute, that it not have exceptions, and not because you think that it will actually prevent all forms of the unlawful conduct, but because it will establish appropriate incentives to limit it. And the incentives are that the law enforcement officers who engage in the torture or make the decision, or in your case, the president, have to accept the risk of personal culpability. And he further argues that in the event, which is a little scary, in the event that it turns out that you're right, you had the person who had the nuclear key in their head, and you torture and you save 10,000 people, that you won't be prosecuted, or if you're prosecuted, the jury won't convict because they will decide you did what was the morally right thing, even if it was prohibited. But I am in sympathy with the idea that there are times when the right answer is you can't do it. And I think it is important, rather than saying we know it's going to happen, for lawyers to say you can't do it.
Well, just to press on it, though, one of the aspects of the OLC memorandum on torture that I think got some people particularly worried was the set of defenses, the necessity defense, et cetera, and the speculation about how a jury might respond, that in the end they might let you off and your odds of winning were pretty good, et cetera. One way of reading that aspect of the memo is that's what's shocking and problematic about the way they perform their function as executive branch lawyers. Now, if we just push on your example, right, you advise the president, you'll be committing a crime, a felony. If you do this, but as your friend, please do it. president does it. There's a set of subsidiary questions which the analysis that you're suggesting, I think, raises. Do you advise the criminal division now to institute the prosecution now that he's done it, right? Or is the idea that, well, no, really, they shouldn't be doing it? So,
The answer to that question has to be yes.
right, so, and then we play it.
Otherwise, I'm just playing.
Exactly. So if you go all the way down the road,
The president says, I want to go to wherever Martha Stewart is.
You got it. Right. You're the man to see, right? So, but I think that when you look at it that way, I think just a potential problem with it as a solution is it starts to seem a lot less attractive as a solution, I would imagine, from the perspective of the president. I mean, you were talking about a hypothetical last night in which the prohibition on the president about shooting down civilian aircraft results in the death penalty. Now, I mean, as interested in protecting the common defense as the president may be, right, violating a statute that results in his certain death, you know, I think as a solution to our problem seems to me not that.
I was going to say, I don't think you turn to the criminal division and say to the criminal division, institute a criminal prosecution, felony prosecution against the sitting president. I believe that there's some OLC precedent for the proposition that you don't do it. I think probably what you do is you refer to the Congress, and the Congress decides whether to institute impeachment proceedings. And if in fact the Congress thinks the president made the right decision, it decides not to institute impeachment proceedings. And then ultimately, when there's a new administration in place, they can make a decision without the sort of overlay of whether they think it'd be proper to bring a prosecution.
Got a bunch of folks who want to talk. David, and then John, and then Mike. David?
Well, I just want, if Randy's account's right, I just think it makes, from a legal realist perspective, some of the highfalutin talk about the importance of constraining the president by law, something that you have to take with a grain of salt, because if the president has actually acted to save the lives of thousands of people, I don't think he's going to get impeached.
Right.
So that means then all of this talk about the statute is really this constraining effect, as Walter was suggesting, right? Isn't all that much of a constraint on him?
Will you take your chances with next administration?
Yeah, you're shaking your head.
Again,
My question is just to ask about OLC and executive branch precedent in this case. I mean, you read about some of these statements in the torture memorandum about this very robust commander-in-chief. I think one could find a lot of other such statements throughout OLC. Why isn't that now the precedent of the executive branch and the law on this subject? We refer, of course, to the Supreme Court, but the executive branch here is making its own interpretation, and the response is, well, the rule of law is in trouble. This has been going on for a long time. We still seem to have something that looks like a government of laws and not of men, because precisely maybe for the points that Randy makes, that if the president goes out too far in front on that, he does face impeachment and other checks and balances. So why shouldn't one to take account of that precedent actually as law more than many of the panelists seem to be willing to?
I'll defer to Walter and then.
I think you should take account of executive branch precedent, but I'm not sure you have the correct assumption about what that precedent is. We have struggled, to me, the single hardest question, generically, with which we dealt at OLC was when may the president or other executive officers violate the law? And the starting point is that the answer to that question cannot be either never or always. And that's what's hard about it. I mean, often we assume that a statute is not intended to limit the presidents, even though on the face of it, it does. But we have never taken the position that where Congress has clearly specified that a law applies to the president, that he is limited by it. So, I mean, our assumption, this is a very, very, and correct me if I'm wrong, Mike Small did the memos on it, Jeff worked on them, and others. Randy, you had this issue. But we find that there are a number of statutes that do subject the president and others to criminal liability. See example, our shoot-down memorandum, which said that it would be a life imprisonment felony for people to continue to authorize facilitate the shooting down of civilian aircraft that's suspected of being drug transport.
Mike, and then Randy. Mike, that has the hand up.
Okay. I also think the short answer to John's question is the paradigm's changed, to sort of come back to Vicki's point. I think that we are clearly operating under sort of a current paradigm in which the president is sort of the preeminent actor in terms of sort of initiating or even being in charge of sort of military actions. And Congress has, some would argue, generally either abdicated a lot of its own authority in this realm or acquiesced in far too much presidential activity. And so if you wonder how we got into this mess, so to speak, part of the answer, I think, is that Congress has not employed all of the checks that it's got, all the authorities that it's got to keep presidents within a certain sort of range of conduct, so to speak. So we mentioned, for example, one clear check that ought to exist if a president doesn't comply with a law is impeachment. But as David points out, that's not likely to work against a popular president. By the way, it's not likely to work against an unpopular one either. It didn't work against Johnson. And so arguably one thing the president might maintain is that either it's unconstitutional or I've got other law on which I can rely on, at which point members of Congress, especially if they're from his party, say, go forth and sin no more.
Randy?
I was going to say, picking up on David's response to what I said about the possibility of impeachment as the remedy was to say, well, then that really means that it's sort of lawless and that Walter's constraint of the law on the president is not real. And I guess I had two thoughts in response to that. One is sort of coming back to Jeff's point from the beginning, which is kind of the absurd hypotheticals are just not a great way to do law here, and to kind of think of the situation in which we know with certainty that the president, through some act that is clearly, undoubtedly unlawful, will save thousands of lives, and therefore, and know that the Congress will respond positively. I mean, it's in some sense, it's an interesting scholarly endeavor, but it probably doesn't have a whole lot to do with how government actually operates. But also, I'm not sure I see any difference between that and the private citizen. And I'm out here walking down the street, and Walter comes up and says, hey, Randy, if you shoot that guy right now, walking down the street there, you're going to save millions of lives. I know with absolute certainty. I also know you're going to be committing a crime. But he says, but you know what, Randy? I think there's an extremely high likelihood the president's going to pardon you. I would do it if I were you. I don't think there's a big difference there.
Why don't you do it?
Peter?
I think there's sort of 2 points here, and they're related. And one has to do, and it's where Jeff started in a way, with the 2 points are about which comes first, or which has primacy, legislative power or executive power. And the second has to do with the transformation of the debate after September 11th. And maybe they dovetail. The Constitution says that Congress has the power to raise and support armies, but no appropriation of money to that use shall be for longer term than 2 years. So if they haven't raised an army, can the president do it because it's an emergency and we need to have an army? I mean, I don't think so. And I think that the starting point, I'm not one of these people who thinks the president can't do anything, and my views of the War Powers Act changed quite dramatically in 1992, so that just shows you. But it seems to me that the starting point for all of these discussions ought to be cases like the steel seizure cases and U.S. v. Nixon, cases that say the president is constrained by law. And that's the starting point. Congress has lots of power, and I think David's distinction I think it's a really brilliant distinction between generic laws enacted ex ante when no one can envision something, and Congress racing into the breach and saying you can't use appropriated funds for war in Cambodia, even though the president thinks it's going to save South Vietnam and millions of lives, same as landmines or ticking time bomb or whatever. Those are two quite different circumstances, and it's really the second circumstance that's where the clash comes. And one very troubling trend I've seen since September 11th is the number of people who say he can do it. He's going to do it anyway. I mean, it's just what they said in Korematsu. As of the time the decision was made, it's okay. And that's not what the rule of law is about, that as of it was an emergency, so the Constitution was under the carpet that day. So I like Walter's suggestion. I think it's really important that we as lawyers try to maintain this idea of rule of law, and the president may take the risk of criminal prosecution. And guess what? If what he did is intern Japanese people, which undoubtedly Roosevelt thought was a great idea the day he did it and was going to save millions of lives or whatever, or he didn't care, that's going to be different from, look, we actually got from the terrorists the code for the nuclear weapon.
Neil?
Yeah, Justice Jackson in Korematsu said that it's one thing for the commander to do it, it's another thing for us to validate, right? Because then it sits around like a loaded weapon. And I think that point he made the point people are speaking about here very, very graphically in those kinds of, in those words. A few people have mentioned that we shouldn't be trying to think through these problems with the absurd hypotheticals. I think is also an important point that that comment is not just directed at academics, it's also directed at people in the political branches who run things, right? The great thing about separation of powers hypotheticals from the standpoint of being a law professor is that it's not hard to find lots of them that are unanswerable. You're talking about a shared power. The Constitution refers to both branches. It's indeterminate, it's not just uncertain, of how you resolve, not even absurd hypotheticals, but hard ones that might even come up. And part of what makes this kind of system function is a commitment by each branch not to go there, right? Not to get to the extreme case in which you have an assertion of authority that seems, from the perspective of thinking of it as a shared power, as unreasonable. And part of what I think, at least three things that are going on, first is the sort of, no one here is a representative of the muscular OLC DOD sort of viewpoint, but it's there, it's in Washington, right? It's palpable. There's sort of a culture, an ethos of the president can do what the president wants, the unitary executive. You see it in Justice Thomas's opinion. Sometimes you see it with Justice Scalia. You didn't see it in the terrorism cases. And so I think that has had a real corrosive effect. I think you also see nature pouring a vacuum. You talk about congressional silence, congressional abdication, whatever you want to call it. And then the last thing, I think, is 9/11. And Vicki Jackson said something that was fascinating to me, which is sort of what's our motivation, right, that actors say. What's our motivation? You mentioned the towers, and you mentioned fear, and you mentioned victims. And what it made me think of was Frank Dunham's rebuttal in the Hamdi case, in which he turned to the court and he said, if you cut through everything, this is what the government is saying. You're scared. That's what the argument is. You are afraid. Trust us. Trust the president. The president will take care of it. And that, to me, is I'm just trying to connect the dots because you threw some illustrations out there that, together with a pre-existing view of very aggressive executive power in a country that's afraid, I think you have a discourse that is manifested in memos in which it can become impossible for a separation of power system to function effectively. You have people making assertions that, if you take them really seriously, it seems to
Leighton?
Yeah, I think
Vicki, you want to go?
it's right on point. I was going to say that address the difference, what I took to be the difference between Walter's scenario and David's response. I guess what Walter's scenario underlines for me is the authority of law is political, right? And David's response is, but that's not legal enough. That's not enough of a legal constraint. But I think there's a difference between the exception that swallows the rule of law and the exception that proves the rule of law. And I think that's what Walter was trying to craft.
Can I just say, I mean, one way to understand the discussion, that for me it remains difficult, is pinpointing exactly what it is about the conclusion in the OLC memorandum with respect to torture that in the end is problematic. Okay? You can talk about the craftsmanship, you can talk about the fact they didn't talk about shared powers, et cetera, but when you come down to the final thing about the president's authority to disregard a statute banning torture, you can avoid the question, we shouldn't think about the absurd hypothetical. The absurd hypothetical they have in their head, I believe, as they're writing it, is the high-value al-Qaeda target who has information that they believe will lead to a disastrous outcome. And they are contemplating that situation and writing a memorandum suggesting that the president in that situation should not be barred by a statute, even if the statute was plain prohibiting it. Now, one way to get around the issue is to say, well, the rule of law approach to that question is it remains prohibited, the statute bars it, the president cannot act, but of course the president has the, in fact, empirical power to command the torture occurs, and then there's various political remedies that result from it. And I guess what I think is a little bit elusive to me is whether that political scenario for what could happen if the president were disregarded, is it right for that to drive the constitutional analysis? Is the fact that that might occur a good reason for lawyers to feel entitled to advise the president that he would be acting illegally were he to disregard the statute? Right? You might say yes, right? It's very important to do that, and the fact that there's some other check on the president, like impeachment, should give us comfort in feeling entitled to say, yes, the president is acting illegally. That the costs of having advised him that he's acting unlawfully go way down, because he could still act and there should still be some constraint. But the other way to think about it is that that's actually not a very useful way to go about thinking about constitutional advice to the president, and that something like a straight-up acknowledgement of one's belief in the need for the president to have this power has a certain legitimacy that's more attractive, and that advising the president in that circumstance that there's some exigency in which he should be entitled to disregard the statute and act would be perfectly constitutional might be a better approach. And I just want to emphasize that ground of the distinction. Is that ultimately where a place where the two positions come out differently, or is there some other aspect to it?
Dawn?
Yeah, I do think very often, even where the statute seems clearly to apply, in reality, we have a situation where it's so clear the president's going to be able to save 10,000 lives and there's no question about it. You can construe the statute to say, if Congress really had this specific fact scenario in mind, they would have allowed for an exception. And so your first argument almost always is going to be to the president, if Congress really had thought about this, they didn't mean to preclude this. So that's, so it's not always going to be, or it's very rarely going to be, you have to risk impeachment. But let me say, and I know we had cases like that, situations like that, where the statute seems clear, but it's true. Congress just didn't think about this. And let me just say the other part that I went in and asked Walter about this. But say you really do have, and if you really did have Congress saying, and we mean situation, exactly like the one that arises, then I think the president shouldn't do it. But another problem I have with Walter's approach, or question I have about Walter's approach, is what if the president can do the act in a secret way? Congress has said clearly you may never assassinate a foreign leader or something like that, and the president can arrange to do it in a way where he won't be held accountable. Is your advice to him going to be, and you should advise Congress that do it in a way that's clear you're responsible, that you violated the statute, or is that kind of accountability going to be part of your advice, or can he do it secretly? In which case, it seems like you have to be saying he really has the power.
Well, two responses. Prefaced by the fact that this is why our motto was at OLC was Dawn Johnson is always right, which made it a lot easier to get our work done once we figured that out. First of all, Dawn, you said exactly in the direction I was going to go on the first point, which is why the problem doesn't exist hardly ever, and why, in fact, one can have a robust view of executive power and still believe that he has to comply with the law. And that is what I think we would call a clear statement rule that you were alluding to. I believe, and this is a robust executive power point, that there should be a very, very strong clear statement rule that a general statute is not intended to limit the president's authority unless Congress has said so clearly and unmistakably, and that resolves many questions if you're within the authority of the president's, where the president has a core power. And we did that with regard to broadcast into Haiti on the eve of the invasion of Haiti, where a statute prohibits offshore broadcasting into a country. It doesn't apply to the president. So I think that takes care of a whole lot of cases, as you were indicating. You say that you resolve most cases by saying you don't assume Congress meant to limit the President of the United States in these circumstances unless they've been clear about it. What if they have been clear about it? All I mean to suggest by the civil disobedience case is that it is a clear acknowledgement of the point that we should not let extreme hypotheticals drive the conversation. It is merely my response to the extreme hypothetical. If it's extreme enough, the president ought to be prepared to go to prison. I don't think we do that. That's my response as to why I'm not going to let the extreme hypothetical twist my view of the law, and why I say OLC should never say what I would say the president's a friend. OLC's view is it's wrong, you can't do it, it's unlawful. I mean, that's the OLC. In the case is extreme, this civil disobedience. You know, I think that's a course in ethics. The only time I leaked information in my years in the government, the morning I did it, I called the White House at 8 a.m. and said, I'm the source of that story. I wrestled with it and thought the only way to do it was, I was only willing to do it if I were willing to immediately turn myself in, because they wouldn't let my memo go to the president. And he had to know, and it was his view, and I knew it was going to be his view. And I think in that circumstance, if I were, I would go to Father Jefferson Powell. I think would tell the president, you owe it to history to if you're going to do this and do it lawlessly, and it's going to be secret. When the time comes that it's no longer secret, you should acknowledge that you did it and be judged by history.
Just three really small points. I mean, the first is maybe to pick up where Walter leaves off by talking about the need for a very strong, clear statement when in this realm. That requirement, as we know, tends to hamstring Congress. And so the question I would raise is whether members of Congress would agree to that, and whether members of Congress would answer any of these questions we've been talking about differently. My guess is that they would. Maybe not all differently, but they would, because most of these are all still weighted in the direction of our initial operating assumption, which we still are exploring, which is a strong, robust executive power in this realm. The second is, I might say respectfully, I don't think any hypothetical in the realm of separation of powers is too absurd, because what else did the Clinton impeachment teach us, other than the fact that no hypothetical in this realm could be too absurd? And I think the other thing, of course, is that September 11th taught us that you can't be too imaginative when it comes to national security.
Chris?
There's an article, maybe 20 years old now, by Meyer, Dan Cohen, and a Harvard Law Review called something like Acoustic Separation in Criminal Law. One interpretation of that might be that this is a circle that can't be squared, and that at some point the law runs out. I mean, he postulates the idea that there are some rules we would like to have be absolute, ex ante, so that people would think there really was no escape from violating them. Ex post, we can contemplate the kill one to save 10,000 with certainty example, and we'd like to allow some relief. The problem is you would need acoustic separation. You would need to be able to give the absolute message to the actor and give the exception rule of law to the tribunal doing the ex post adjudication, and you can't unless you postulate a very bizarre society that we would find unacceptable. Some black box that would do the adjudicating, and you'd come out the other end for some mysterious reason, and then you'd have to go into a witness protection program so that nobody would know your identity and so it wouldn't work. So you can't do the separation. You can't have the conversation with the president. What are you going to do when the president says, well, what do you think will really happen to me? You know, at that point, do you lie to him? I think you'll go to jail. When you really think, no, a jury would give you relief, or you won't be impeached. So it may be that just this is a problem that just the law runs out. We're expecting too much of law, and there are a lot of different places you can plump. You can come to one of the various positions that have been stated here as the right outcome. You know, you say it's unconstitutional, or you say it's no, in truly exigent circumstances, you can do it. But then you run into David's problem. You can't actually write that memo with that paradigm case in mind to apply it to just the paradigm case. That memo doesn't apply just to the high-quality Al-Qaeda target where you're they do magical things, making imminent disappear in that memo. So there are no constraints that they were able to figure out on the limits of that power. And this may be it was one of those moments in which the law doesn't have sufficient equipment to come to what you would really like to do. Because I would put it to you, the civil disobedience solution is one that I find attractive. On the other hand, if I think about it, if you really want to do strictly private justice to the person who has taken that civil disobedience step, you would really like to say, I'm not going to punish you for that. Because really, I wanted you to do it. And so how morally can I punish you? Why am I punishing you? It's so I'll be able to send a message to the people who come after you, not to assume that this is too big an exception. So I'm actually using that individual to send a lesson to somebody else when my judgment of that person's culpability, I think would not lead me to administer the sanction. So you say it's got to be civil disobedience, but that's an imperfect solution. That may be the best solution. But I think that's still an imperfect solution to this problem.
John Harrison.
I think the law may offer a little bit more of a solution than may seem. I mean, this is a Splunkian explorer's problem, and it's a prerogative problem. That is, can the president dispense the law on the basis of ex post information that wasn't available to the lawmaker ex ante? And I don't think it's an accident that the primary sanction that's being talked about is the criminal sanction. And as to the criminal sanction, the president does have a prerogative power. He's got the pardon power. And one of its purposes is to be used for great reasons of state. For example, when it's, the example in Federalist, when it's necessary to stop some kind of coup or rebellion by offering a pardon to the ringleaders. Well, if the president really wants to do something, I would say he can pardon himself. I know that's a matter of dispute. He can certainly pardon and promise to pardon the people he's going to offer to actually torture the person and therefore relieve them not of all responsibility, but of the single most important piece of responsibility. And as I say, I don't think it's an accident that little piece of prerogative is still in there in what is basically a rule of law system.
Yeah. I just want to note that one interesting factor about this conversation, or fact about it, is that it is dovetailing nicely with the next panel. We're really ending up talking as much about what the proper role of the lawyer is as we are about the law that she is to be administering or advising about. And that seems to be entirely right. And I want to give you a different hypothetical to illustrate why I think that part of the answer here is something that Walter was talking about yesterday with Charles Freed, which is the possibility of doing doctrine, of there being law, as John was saying. Here's my hypothetical. The president, I'm the White House counsel, and the president tells me that the Joint Chiefs has reported that the Russians have launched a strategic nuclear strike, and that in 15 minutes we will be both devastated and unable to respond. The president says, Jeff, do I have the lawful authority to launch our strategic nuclear deterrent in response? Get it off the ground before they hit us. I personally think that using the strategic nuclear deterrent would be one of the most immoral conceivable acts. I think the president should not under any circumstances do so, and I realize I have just wrecked my chances for running for election in 2008. I think it would be grossly immoral. I also think it would be entirely unprofessional and unethical and outside my role as a lawyer to say to the president in the hope of getting him to do what I believe to be the morally right thing and sit on his hands, to say to him, well, as a matter of fact, Mr. President, there is a substantial legal authority suggesting that you cannot in fact engage in war without congressional authorization, and therefore you lack the power. That's not ethical lawyering.
Peter, you want to say something?
Yeah, I think this, I agree with Jeff. This dovetails with what we're about to talk about and with David's question before. And some of it has to do with the OLC-centric nature of the crowd here. But the question is how shall I advise the president? And then David talks about the constitutional analysis can't be driven by X or by Y. And yet, the Supreme Court has said, if it has, you can't detain U.S. citizens in the United States for purposes of interrogating them. And I have no doubt that your advice to the president with a square, like an on-point holding of the U.S. Supreme Court would be, now obviously you can weasel out of it by saying that they didn't know this, right on point. The court has said the president can't do this. There's no exception here. We assume that he wants to find out something really important, but he can't detain people for that purpose. I assume your advice to the president would be the straight constitutional advice, the ethical advice that Jeff has suggested. This is prohibited by a Supreme Court decision, period. And so then my only question is, why wouldn't you therefore always, and bearing in mind that there are bureaucratic pressures on you pushing the other way and institutional prerogatives that maybe rightly push you the other way, why wouldn't your starting point always be, let me just hold the compass true for a second here and see what I actually think the law is and recommend that. And the law may have no exception because the Supreme Court sometimes says.
What was interesting about this discussion is primarily we started from the premise that what Congress did should be binding on the president, Although at the beginning of our discussion, we had some indication that there might be some areas, even if it's just limited to who, picking the generals or picking the leaders of the particular battles, where even if Congress acted in that area, it would not, the president could easily discard it because constitutional action was unconstitutional. I'm not so sure that the landmine example is so easy that a president would have to follow that. Where torture is, as we move away, if we start from the premise that there are some things that Congress can't prohibit the president from doing, where is torture on that line? Those questions, of course, are the ones that will go to OLC, and I think we are OLC-centric here for a good reason, which is that courts aren't going to decide these cases. Impeachment is not going to decide these cases. The only place where these cases are going to be decided is in the Office of Legal Counsel at the Justice Department, and that's our segue to the next panel.
Okay, 15-minute break. This is a very important piece of paper for anybody wanting to catch a plane this afternoon who wants my help. You need to let me know your departure times. Thanks.
I am